Thank you all for your continued support. This week we have crossed 1000 subscribers and it is all because of you. Today I am going to talk about the power of arrest under these special legislations. The recent judgment delivered by a bench of Justice Sanjay Kishan Kaul and Justice K.M. Joseph delved into the issue and the judgment is Union of India versus Ashok Kumar Sharma and others. Let me give you a brief fact about what had happened really. An online complaint was registered against a pharmacy alleging that it was operating without valid license. When the drug inspector conducted an inspection, it was observed that the owner of the medical store admitted that he had stored medicines but without proper license. Thereby this was considered to be an offence under section 18 and 27 of the Act. Now an FIR was registered with the complainant being the drug inspector. The respondent owner filed a writ for quashing of the FIR. The Honourable High Court allowed the writ petition quashing the FIR, observing that section 32 of the Act must be scrupulously observed and it is the mechanism for prosecution offences and there is no scope for registration of FIR under CRPC. Now let us look at the findings of the High Court first. As per section 32 of the Act, only inspector, gazetted officers conferred with the authority, an aggrieved person and a recognized consumer organization is eligible to make a complaint. It held that the Act was a special act which was enacted for trial of offences committed under the Act. So the Act had an overriding effect over all other acts. Therefore, provision of CRPC will be applicable to the extent it is provided in the Act itself and not beyond it. Since FIR is registered under section 154 of CRPC, the said provision would not be invoked. Now, the submissions on behalf of Union of India were that the High Court was in error in holding that FIR under CRPC cannot be lodged in respect of the Act. Ms. Pinky Anand, the learned ASG, had submitted that certain offence under the Act was cognizable offence and therefore it was inconceivable that FIR cannot be lodged under CRPC. Section 36 AC of the Act contemplates these certain offences to be cognizable. The amicus curiae was Mr. Nagamuthu, who is a senior advocate, and he submitted that prosecution can be launched only in manner provided in the Act in regard to the offences under the Act as covered under section 32. Now section 2A defines bailable offence as offence which is shown in the first schedule, and these are typically of course bailable. Non-bailable offence means any other offence. So cognizable offence is defined under section 2C and is an offence for which arrest can be made without warrant, whereas section 2D, if you look at CRPC, defines complaint, and then there is investigation, police report, which is defined under section 2R and is given to the magistrate under section 173. Section 154 provides that every information which is relevant to the commission of a cognizable offence given orally to an officer in charge at police station should be reduced in writing and be read over to the informant. Section 155 provides information for non-cognizable offences and the manner of investigation. Section 156 defines police officers' power to investigate cognizable offences over local jurisdiction. However, 156(3) empowers magistrate to order such an investigation. This is the resort that typically complainants have when their FIR is not registered. Section 173 provides for report to be given on completion of investigation and submission of report to the court. Section 190 then provides that a court may take cognizance on basis of police report. Now a comparison between section 32 of the Drugs and Cosmetics Act and 190 of CRPC deals with cognizance of offences, which makes it abundantly clear that the lawgiver has provided for distinct modes in regard to prosecuting of offences under general law, that is the CRPC, and special provisions as contained in section 32 of the Act. The inspector under Drugs and Cosmetics Act possesses prescribed qualifications. Section 22 vests powers in inspector that a complaint can be moved by inspector and not by police officer under CRPC. Similarly, any person and or recognized consumer association as per section 26, after submitting prescribed fees in the prescribed manner, can get any medicine tested or analyzed by government agency, and after they have received a report, they can go ahead and file a complaint, therefore invoking section 32 to prosecute the offender. Now, section 32 of the Drugs and Cosmetic Act declares that no court inferior to Court of Sessions shall try offence punishable under chapter 4, thereby being the court of original jurisdiction. Under section 193 CRPC, no court of sessions can take cognizance of any offence as court of original jurisdiction. This is very clear in that sense, that we know that court of sessions cannot by itself become an court of original jurisdiction unless the case has been committed to it by a magistrate under CRPC. So, here as far as Drugs and Cosmetics Act is concerned, we see that court of session becomes the original jurisdiction, it gathers original jurisdiction. Now, section 36 AC of the Act contemplates that arrest, this is 36 AC of the Drugs and Cosmetic Act, that there will be arrest and certain offences are made non-bailable. So, it further states that no person who is accused of offences mentioned under section 36 AC shall be released on bail or on his own bond, and this is important because it says that unless the public prosecutor has come and he has been given an opportunity to oppose the application of such release, no bail can be granted. However, special powers of the High Court under section 439 of CRPC are preserved completely. Now, there were many cases upon which the Hon'ble Supreme Court laid reliance on. But if we see, then while adjudicating specifically on 36 AC, we see that Jeevan Kumar Rawat versus CBI, which is a case which was about Transplantation of Human Organs Act 1994, or popularly known as TOHO Act. The para 21 of the judgment says that ordinarily any person can set the criminal law in motion. Parliament and the state legislatures, however, have kept in view the sensitivity and the importance of the subject, and therefore have carved out specific areas where violation of any of the provisions of a special statute, and in this case the case that I am referring to, which is the TOHO Act, can be dealt with only by the authorities who have been specified therein. So, it is very simple. Anybody who wants to do the criminal law in motion, specific acts have actually talked about specific people who can set that law in motion. Now, Jamiruddin Ansari versus CBI, which was basically a case under MACOCA, which is Maharashtra Control of Organized Crime Act 1999. This judgment is important. Why? Because the full bench which was constituted to hear this matter by a majority took a view that a private complaint under section 9 of the MACOCA Act was not trammeled by the requirement under section 23. So, there are different sections which have been defined under MACOCA, and this act, the MACOCA Act, very clearly imposed sanctions that any case could be only done when there was a prior approval which was required to be given by the rank of Deputy Inspector General of Police, and therefore an embargo was imposed on investigation which could be only carried out by a police officer of rank of Deputy Superintendent of Police and above. So, there are specific embargoes that have been placed in special legislations, as we see. Similarly, there was a very important case that took place, which was again decided by Honorable Supreme Court, which was on Prevention of Corruption Act. There were many cases on Mines and Mineral Development and Regulation Act, that we see that special provisions have been brought about in these special legislation in terms of who is going to be the complainant, how is it that it is going to be registered. All of this has been very clearly specified. So now in this judgment, they very clearly talk about the Lalita Kumari judgment and what would be its effect as far as these special legislations are concerned. Now, as we know that a constitution bench of the Honorable Supreme Court had held that registration of an FIR is mandatory under section 154 of CRPC if the information discloses commission of a cognizable offence and no preliminary inquiry is permissible in such a situation. So therefore, preliminary inquiry may be conducted only to ascertain whether or not a cognizable offence is disclosed or not. Now, Lalita Kumari happens to be one of the most important judgments, but it did not consider the special acts or special legislations which were brought about. So therefore, the principle which was laid down in Lalita Kumari is not attracted when information is made before police officer making out commission of an offence under chapter 4 of the act mandating registration of FIR under section 154 of CRPC. This is important. I would also suggest that when you are watching my video, it is recommended that you have the concerned judgment also with you, so that you can understand and cross verify the important judgments that I have been talking about. Now, coming back to this judgment, if information is relatable only to cognizable offences under chapter 4 of the act, then the police officer would be out of bounds and he has no role to play in the investigation, as neither he nor any other police officer has any specific role as far as investigation is concerned, because that will be done by the inspector. So what is his duty? His duty lies in referring the complainant to the concerned drugs inspector, and if he is in receipt of information about an offence under chapter 4 of the act, he must promptly notify the concerned drug inspector. Now, looking at power of arrest under the act, we all know that section 41A of the CRPC, which was inserted in 2010, 1st November 2010, provided for issuance of notice by the police officer in all cases which were covered under subsection 1 of section 41 of the CRPC, where the arrest of a person is not required to appear before him. As long as a person complies with the notice, section 41A subclause 3 prohibits arrest unless the police officer, for reasons to be recorded, and this is important that the reasons should be recorded, is of the view that he is, that is, the person who is accused is to be arrested. So this is the process as far as 41A is concerned. Now, arresting of a person involves an encroachment on his personal liberty. So, and we also understand that Article 21 of the Constitution of India declares that no person shall be deprived of personal liberty and life except in accordance with the procedures which have been established by law. So, the understanding that we require here to make out is that the inspector, can he have the power to arrest or not as per the procedures which have been established. So there can be no doubt that power to arrest any person therefore must be premised on a law which authorizes the same. The conundrum, however, is posed by the aspect relating to arrest. So undoubtedly there is no express power on the inspector to arrest under the act. This becomes very clear, that can a drug inspector, here when I am referring to inspector actually means the drug inspector. Now let us understand who is a drug inspector. There are qualifications which have been prescribed in the act, and it is prescribed in the rules as well, and these are indispensable. So anybody who has these qualifications can only become drug inspector here, and he can represent a carefully chosen value judgment by the legislature to assign the implementation of the act through the competent hands of qualified persons. So we understand that the legislature had an understanding that we require specific qualification from these officers, and then they can only become drug inspector, keeping the police officer out of the categories of persons who could prosecute offenders for offences under chapter 4 of the act. It is very clear that was probably the intention of the legislature, ensuring that the police officers were kept out of it, and the drug inspector was the person who was to look at it. Now coming to the most important finding in this judgment, that an arrest can be made by the drugs inspector in regard to cognizable offences falling under chapter 4 of the act without any warrant, and otherwise treating it as a cognizable offence. The other important point was that there are many cases where FIRs have been registered in regard to the cognizable offences falling under chapter 4 of the act. So the Hon'ble Supreme Court, exercising its right under under article 142, then directed that all these cases which were there should be now handed over to the drug inspectors if it has already not been done, and it is the drug inspectors who are supposed to now take action on the same in accordance with the law. These are some very important findings that we saw, and this was a very well written judgment, specifically if somebody really wants to understand how criminal law in India works and the provisions of CRPC. I think this is one of the very good and very crisp judgment. Now in regard to the power of arrest, police officers do not have power to arrest in respect of cognizable offences under chapter 4 of the act, but this has only started to take in effect from the date of the judgment. So it was not that it will have a retrospective effect, it was supposed to be from the date of the judgment. And also further, the Supreme Court had also directed that the drug inspectors who carry out the arrest must not only report the arrests but also immediately report the arrests to their superior officers. So very well balanced judgment, something which has gone into the depths of CRPC, and most of the important judgments you will find the reference made over here, be it Lalita Kumari, be it Arnesh Kumar, be it the state of Delhi versus Sanjay. All of these judgments have been discussed in it. I understand that this has been a little long video, but the judgment itself is some 186 pages, so therefore this kind of extended into a little longer time period. Thank you so much for watching, and do like my videos, subscribe to my channel and share my videos if you like them. Thank you so much and have a wonderful day.